In this video, we will continue our examination of the party's rights and remedies where the buyer rejects the seller's non-conforming tender of goods. In particular, in this video we will assume that the buyer has the legal right to reject the seller's tender of goods, and we will look more closely at what the buyer needs to do to actually reject the goods. Stated differently, the buyer may have the legal right to reject the seller's tender of goods, that right to reject being defined by the perfect tender rule and its exceptions. But the buyer still needs to exercise that right, make an effective rejection of the goods. So, how does the buyer make an effective rejection? The answer to this question requires that we look at several different provisions of Article 2. And the best place to start is Section 602, subsection 1 of Article 2, which reads that rejection of goods must be within a reasonable time after their delivery or tender. It is ineffective unless the buyer seasonably notifies the seller. So, to make an effective rejection, the buyer must do two things under this provision. First, the buyer must reject within a reasonable time after delivery or tender of the goods. Reasonable time depends entirely on the particular facts and circumstances involved. Relevant factors may include the express terms of the party's contract and whether those terms limit the time the buyer has to inspect and reject the goods. In the absence of express terms in the party's contract, a reasonable time depends on the time that would be reasonably necessary for the buyer to inspect the goods to ascertain whether they are conforming to the requirements of the contract, and the difficulty of discovering any defects in those goods. The second thing buyer must do to make an effective rejection is to seasonably provide notice to the seller of the rejection. Seasonable is a defined term in the UCC, defined specifically in Article 1, Section 205, subsection B. And that provision defines seasonable to mean within whatever period of time agreed upon by the parties, otherwise, in the absence of the parties' agreement, within a reasonable period of time. So the buyer's failure to reject within a reasonable time or to provide seasonable notice will render a rightful rejection by the buyer ineffective. And an ineffective rejection is tantamount to a failure to reject. It is deemed an acceptance by the buyer of the seller's tender. So to make an effective rejection, the buyer must reject within a reasonable period of time and provide seasonable notice to the seller of the buyer's rejection. But even then, the buyer's work is not yet done because Section 605, subsection 1 of Article 2 reads as follows. The buyer's failure to state in connection with rejection a particular defect which is ascertainable by reasonable inspection precludes the buyer from relying on the unstated defect to justify rejection or to establish breach where A, where the seller could have cured if stated seasonably, or B, in a deal between merchants when the seller has after rejection made a request in writing for a full and final written statement of all defects on which the buyer proposes to rely on for its rejection. So, although Article 2 does not require the buyer to include anything in particular in its notice of rejection made to the seller, indeed, Article 2 does not even require rejection to be made in writing, Article 2 does specify the consequences of a buyer failing to identify its basis for rejecting. Specifically, 605 subsection 1 says that if the buyer's rejection fails to identify a particular defect, and that defect was ascertainable by reasonable inspection, and under 1A, the seller could have cured the defect had she been given notice of it, or under 1B, in a transaction between merchants, the seller requested the buyer to particularize any defects and the buyer failed to do so, then the buyer cannot rely on any unstated defects to reject the goods or to make a claim for breach. Stated differently, rejection on the basis of the unstated defects is unjustified, it's wrongful, and a wrongful rejection puts the buyer in breach. You might think of this provision as a special application of the implied duty of good faith, that a buyer who fails to notify the seller of the seller's breach, where the defect was readily discoverable to the buyer and could have been cured by the seller had the seller been made aware of it. That kind of buyer is not acting in good faith by hiding the defect from the seller. The upshot of all this is that although the buyer is not required to state the reasons for her rejection in her notice of rejection to the seller, the buyer should still do so. In practice, you should always advise your buyers to provide notice identifying defects where the tender is non-conforming. It just makes good business sense to do so, because under 605, a buyer's failure to identify the nonconformity in its notice of rejection makes the buyer's rejection on the basis of that nonconformity unjustified, wrongful. It puts the buyer in breach. 606 of Article 2 provides a bit further guidance on what makes an effective rejection. Specifically, subsection 1 of 606 tells us what constitutes an acceptance of the seller's tender of goods. And this matters for purposes of rejection because acceptance is the opposite of rejection. Remember, the buyer has a binary choice to make with respect to each commercial unit that the seller tenders. The buyer must either accept or reject. The buyer must do one or the other, and she cannot do both. So, to the extent the buyer accepted the goods, the buyer has failed to reject the goods. We will revisit 606 in next week's module. But note now two things that subsection 1 of 606 says constitutes an acceptance of the goods and therefore precludes the buyer's rejection of the goods. First, under subsection 1b, the buyer's failure to make an effective rejection after a reasonable time to inspect for conformity constitutes an acceptance of the goods. Stated differently, silence or inaction by the buyer after the seller's tender constitutes an acceptance by the buyer. You might think of this provision as a corollary to 602 subsection 1, which we just looked at. After all, that subsection says that an effective rejection requires the buyer to seasonably notify the seller. Finally, under 1c, if at any time the buyer takes any action inconsistent with the seller's continued ownership of the goods, then the buyer has accepted the goods. So any use, consumption, or destruction of the goods by the buyer, any resale of the goods by the buyer, any of these things constitutes the buyer's acceptance of the goods. Here it is important to remember, however, that under 513 subsection 1, the buyer has a right to reasonable inspection of the goods before accepting them. So if the buyer's use of the goods is reasonable and necessary to determine whether the goods are conforming, that use is not considered acceptance, even though such use might otherwise be considered inconsistent with the seller's ownership of the goods. That use is considered consistent instead with the buyer's right to inspect the goods under section 513. Note also what is not listed as constituting acceptance under subsection 1 of 606. Buyers taking possession of the goods. Buyers taking possession of the goods is not the same thing as the buyer accepting the goods. Taking possession of the goods and accepting the goods are totally separate and unrelated. Indeed, it may be impossible for the buyer to exercise its right to inspection of the goods for conformity without first taking possession of the goods. The two are totally separate and unrelated. So now, after looking at three separate sections of Article 2, 602, 605, and 606, now we know what it takes for the buyer to effectively reject the seller's nonconforming tender of goods. But even then, the rejecting buyer's work is not yet done because once the buyer has rejected the goods, the buyer has certain responsibilities. Assuming the buyer has taken delivery of the goods and is in possession of them, and upon inspecting the goods has elected to reject them after discovering a nonconformity, the buyer cannot simply toss the goods, take them to the dump yard, or set them ablaze maniacally. Remember, as we just noted, the buyer cannot do anything that is inconsistent with the seller's continued ownership of the goods. Any post-rejection action the buyer might take that is inconsistent with the seller's continued ownership of the goods has the effect of the buyer revoking its rejection and converting it into an acceptance of the goods. So what are buyers' responsibilities with respect to the rejected goods in its possession? Well, the general rule is set forth in section 602, subsection 2b, which reads that if the buyer has before rejection taken physical possession of the goods, he is under a duty after rejection to hold them with reasonable care at the seller's disposition for a time sufficient to permit the seller to remove them. So the buyer has an obligation to take reasonable care of the rejected goods, reasonable care for a reasonable period of time to allow the seller to remove them. Note also that section 603 articulates an additional rule where the buyer is a merchant. A rejecting merchant buyer has the obligation to follow any reasonable instructions of the seller with respect to the rejected goods in the merchant buyer's possession. And in the absence of any such instructions from the seller, if the goods are perishable, then the rejecting merchant buyer has the obligation to try to sell the rejected goods for the seller's account, with the buyer to be reimbursed for her effort by the seller or out of the proceeds of any sale, pursuant to subsection 2 of section 603. Finally, all buyers, merchants and non-merchants alike, after reasonable time has passed and the seller has not provided instructions or removed the rejected goods, may elect to either store, reship, or resell the rejected goods for the seller's account. Pursuant to section 605, the buyer has the right to do these things, even though such actions would otherwise be inconsistent with the seller's continued ownership of the goods. Note also the statutory language here. The buyer may do these things, so the buyer has the right but not the obligation under Section 604. If the buyer does elect to store, reship, or resell the seller's rejected goods, then the buyer can be reimbursed by the seller or out of the proceeds of any resale. So, to briefly summarize what happens after an effective rejection, the buyer has an obligation to use reasonable care regarding the rejected goods until the seller takes them back. And merchant buyers are further required to follow any reasonable instructions of the seller as to the rejected goods. But where the seller neglects to reclaim the rejected goods or provide instructions to the buyer has the right but not the obligation to store, reship, or resell the seller's rejected goods under Section 604. And that concludes our look at how the buyer may make an effective rejection of the seller's nonconforming tender. In the next video, we will continue our examination of the party's rights and remedies where the buyer rejects the seller's nonconforming tender of the goods by assuming the seller has made a rightful and effective rejection and then focusing in on the seller's limited right to cure its breach.